We have a tiny bit more information about what happened at Lively's deposition by a trickle of more testimony from her deposition. First, we learn who all was there. So, Lively was there. She was accompanied by 7 of her attorneys, including Ezra Hudson and Michael Gottlieb. And the Wayfarer parties, which by my count is 8 total defendants, were represented by 6 attorneys. There was also an attorney for Jonesworks, and there were 2 attorneys for Judd Wallace present. Interestingly, Judd wasn't at the deposition. It looks like it was just Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and Jennifer Abel. I've read so many deposition transcripts. It's funny because you really do get a sense of what happened in the room when you read it. And this first part is your typical announcing for the record who you are and who you represent. And I don't know how to describe how, but you can sense the nervous energy in the room by how the transcript reads. I think it comes through some of the really innocuous fibbing that happens. I represent the plaintiff. That's not exactly what is written here, but it just comes through. There's also a heated back and forth at the beginning about whether or not standard stipulations apply. FRCP stands for the Federal Rules of Civil Procedure, and standard stipulation under Rule 32D3A is the customary agreement between parties to reserve certain types of objections until trial rather than making them during the deposition. For example, objections regarding the competency of a witness or the competency, relevancy, or materiality of testimony wouldn't be waived if they're not raised right there on the record. Because typically speaking, when a party asks a question, the deponent's lawyer needs to object to the question in the moment to preserve their right to fight that later on. If they don't raise the objection during the deposition, then it's presumed waived. So if there's a stipulation at the outset of the deposition, those specific objections are not waived, then they can be raised later at trial. That's important because when it gets to trial, the parties are going to fight about which parts of the deposition can come in as evidence and which parts cannot. And they will fight about those objections, and the court will rule on whether or not testimony can come in based off of the objections raised. So, being in a deposition, answering questions in a deposition, and reading a deposition transcript is not like reading a normal conversation because there will be a question. Inevitably, there will be, or most likely, there will be objections. And then the deponent still has to answer the question. There's only very few instances, and usually that's with respect to some kind of privilege that prevents them from answering that specific question. Very, very narrow situations in which the witness will be instructed not to answer by their lawyer. But otherwise, even if there are objections, and sometimes those objections can take pages because the lawyers get really heated, they still have to answer the question, even if it's like, did you see the sun outside today? Moving on, there's a discussion about how the plaintiff, Lively, is designating her whole transcript as confidential under the protective order. That means, and that's why the parties that want to use part of their deposition transcript have to seek for it to be unsealed because it is presumed confidential pursuant to the protective order. So that's what that's referring to. And then we get a glimpse into the first moments where Brian Friedman is actually questioning Blake Lively at the very kind of start of the real deposition. So he asks her to state her full name, her age, In a typical deposition, you might ask them to state their address. You might start from the beginning of time, tell me about your resume. In employment cases, there's a lot of time spent on the plaintiff's background and how they get to the job that they're in, the job that created the lawsuit. Here, it looks like Friedman just jumped right in, said, "How long have you been an actress? And you agreed to play Lily Bloom in this movie, correct?" Then she's asked if she had heard about the book prior to agreeing to play the role, and she asked a clarifying question. While technically the lawyer asking the questions is the only one that should be asking the questions, this happens, we're humans. She says, prior to agreeing. Friedman says yes, and she says yes. Prior to agreeing to be Lily Bloom in the movie, she had heard about the book. Now, some people are saying that's perjury because there's videos of her saying that she hadn't heard about the book until she was asked to be in the movie. So it's very possible that she heard about the book after being asked about playing the role of Lily Bloom in the movie, and prior to agreeing, she then therefore knew about the book. So I'm not going to get on the train of this is perjury, because perjury is lying under oath. And I think that Lively would have been very well prepared for answering these types of questions. It looks like she answered it well. Where her testimony starts to fall apart is when she's being asked very specific questions about the allegations that she brought forward. So she has brought a claim against Judd Wallace, claiming that he has slandered her or defamed her. And so Judd Wallace's attorney asked her to identify any written format of this type of information that she can identify, since she has brought a claim against him for that. And she cannot identify it. This is where the lawyer drills in. So you can't think of an article or a video or something like that that was defamatory or derogatory towards you. She cannot identify it. This is important because Wallace will be able to use this to say there is no written form of this defamation. So the claim against him should be dismissed because the plaintiff herself cannot identify that written format, which is required to prove that claim. The next highlighted part squares her in on where filming of the movie took place and the timeline, getting her to testify that the filming happened starting in May 2023. It occurred in New Jersey. When it picked back up again, January 5th, 2024, was also being filmed in New Jersey. There were no other locations where there was filming. And the last bit is Wallace's attorney trying to get her to define why she used the phrase bury in her complaint. She confirms that she felt once she read the text messages or documents or what have you, it was to reputationally bury her. That's what she understood. Now, the transcript goes on, and she goes on to say that when Steve Sarowitz said there would be two dead bodies by the time this was done, she did feel physically threatened. There is more to that, but it looks like the attorney redirected it with respect to reputational harm because this is not a criminal case. We don't have criminal claims. So that was just sort of odd. But we can glean from this last bit where the attorney locks her in on when the premiere was. It says something to the effect of, so that's when you testified that you first felt negative reputational harm. And she confirms that. And that's all for today until the next deposition drop.